Okay, we're going to do essay question 1 from 2013 July, professional responsibility essay. So as always, we're going to go to the call to question first. And the call to question states, what ethical violations, if any, has Tom committed? So, we have Tom. I'm wondering if Tom is an attorney. Turns out he is. Number 2, ethical violations by Alan. Okay, fine. Now, in this particular essay, and again, if you have not read this essay, if you've not gone over the fact pattern before listening to this, push pause, read the fact pattern slowly and carefully, read it at least 3 or 4 times. You'll be able to follow a lot better. In fact, if you even want to read the model answer before you tune in, that's actually not a bad idea because it'll help tie together everything so you fully understand it and you're easily able to follow. I mean, anytime you do go through an essay, you've got to review the model answer extremely thoroughly and extremely carefully. Don't skim it, don't look at the headings. Make sure you fully understand the arguments, the facts that are involved, the reasoning behind it, how you got there, why I made such conclusions. Not necessarily that all the conclusions are correct or they may disagree with you. That's totally fine if we're not in. Now, some conclusions have to come out a certain way. There's just no ifs, ands, or buts about it. Other conclusions are just like, this could go either way. So I don't mind if you go this way and I go that way. Doesn't mean either one of us are right or wrong. It just means that we see it a different way, and the jury might see it your way, might see it my way. Okay, so here with Tom and Alan, turns out the ethical violations kind of are skewed. Some of the things Tom did can be attributed to Alan, some things Alan did be contributed to Tom. So don't worry about your organization in terms of like, well, which one did it? It doesn't matter, just put it wherever you want. Because as you'll see, a lot of the issues will dovetail between the two. Okay, let's take it from the top. Patty was hit by a car whose driver did not notice her because he was texting. Joe, a journalist, wrote a story about Patty's texting accident. Patty contacted Tom, a real estate lawyer. Why are you contacting a real estate lawyer to represent you in a personal injury case? And I was asked to represent her in a claim against the driver. Okay, now we're having a real estate attorney represent you in a personal injury case? Well, that's no problem because Tom can get competent. So the duty of competence says a lawyer may accept representation where the required level of competence can be achieved through preparation and study or by associating with a lawyer of established competence. So as long as you are able to get the established skill, thoroughness, preparation, and knowledge necessary for the representation, you can become competent in a matter, no matter how complex it is, even if you've never done it before. You just have to become competent. So this is fine for a real estate attorney to take on a personal injury case. A tax attorney can take a criminal case. A family law attorney can do construction defect if they want, as long as they become competent. There's many, many ways to get competent. You're studying for the bar. One of the ways you get competent is you're studying. You're getting experience through law school. You're associating with someone who knows what the bar exam's about. So you're doing all the things necessary to become competent so that you can pass the bar. That's why it says you have to have the minimum level of competency required in order to get your license. Okay. So here, Tom agreed and entered into a valid and proper contingency fee agreement. No need to discuss it. All right. I pay very little attention to it. Just more to give you the rules so that when you're reading it, you can kind of just refresh on it. Which I think is always good to refresh on things. But in the exam, you don't need to waste your time writing it. Because they tell you it's valid and it's proper. It's the examiner's way of saying, we're not testing this issue here. Tom later told, again, told Patty that he referred her case to Alan. So he later told the case. Wait, did you even communicate with her to ask her whether or not that was fine? So that might be breaching the duty to communicate because Tom has to inform her about any significant developments in the case. And I think referring my case to another attorney is something I'd want to be apprised of if I was the client. So you have a duty to, competence, okay. Duty to communicate, probably messed up on that one. Because you probably should have told her that he had referred the case. Now, he did refer the case to Alan, experienced personal injury attorney, which is pretty good. That's a good way to obtain competence is by handing off the case to somebody else, and she did not object. Unknown to Patty, Alan agreed to give 1/3 of his contingency to Tom. Okay, now we have fee sharing between two lawyers. So under the ABA, you can share fees as long as it's in proportion or each assumes joint responsibility. Well, here, it doesn't seem like, we don't know. I mean, Tom, we don't know what kind of work Tom did, but is Tom getting like 5% of the fee because he did 5% of the work? If so, that's fine. But of course, it has to be in writing and you have to have the client's consent, neither of which happened because it said Tom told Patty that he referred a case to Alan. And Patty didn't even know that Alan agreed to give this contingency fee to Tom. 1/3. Wow, he's actually getting 1/3. Alan agreed to give 1/3 of his contingency fee. So Tom got a 33% referral fee in a sense. Okay, so under the ABA, it's non-proportion, there's no joint responsibility, we don't have the consent of the client, and it's not in writing. Now, under California, it's similarly a violation. California allows the pure referral fee, which this seems to be. This is a pure referral fee. Alan's kicking the money back to Tom, 1/3 of the money for recommending him the case, which is fine under California. Provided the client is aware of it, you get the client's informed consent, the client has full disclosure of what's going on, knows what the amount is, knows who's getting the fee, and also the agreement between Alan and Tom must be in writing. So none of those things happen, violation of California. So again, California, okay for referral fees. This is the new rule too. So California is okay to do new referral fees, client consent. Let's see, what else is, just want to make sure that I encapsulate the rule perfectly. Okay, fully disclosed the terms. The two lawyers agreement in writing. So I'm going to read you the rule just a California allows lawyers to share fees provided the client consents after writing after the lawyer fully discloses the terms of the fee sharing agreement, including who will receive a share of the fee. So the client has to be fully informed of the entire details of the referral fee, must know who's going to receive it, and the fee sharing agreement between the two lawyers here, Tom and Alan, that has to be in writing, none of which happened. Client did not consent, client didn't even know, none of the terms are disclosed, she knows nothing what's going on, and there was no agreement between Tom and Alan in writing. So that's the new rule. It's the new rule you need to know going forward for the bar. Okay, continuing on. Thereafter, Alan sent a $200 gift certificate to Joe with a note saying, in your future coverage of the texting case, you might mention that I represent Patty. This is a little vague about what's going on. A lot of people had trouble with this during the actual exam, and I still don't really understand what's going on here either. But what the examiners were looking for was, you may not give anything of value to a person for recommending the lawyer's services. But it's hard to tell whether or not Alan sent this to Joe to hey, will you recommend people to me in the future? Is he paying Joe that money to recommend him as an attorney? That's kind of it doesn't matter. It's really kind of hard to decipher what's going on there. But as long as you raise the issue for them. Also, this looks like maybe a type of advertising. He's trying to get his name in the paper. Well, that's fine because he does represent her, so it's not false or misleading. Really tough to determine what the examiners were looking for there. And finally, let's go to the last paragraph. Patty met with Alan and told him that Walter, a homeless man, had seen the driver texting just before the accident. Well, his testimony is admissible. I don't know how credible it's going to be. I mean, this guy's probably crazy, drunk, and who knows what he saw. But a lawyer may pay the witness's reasonable expenses in having to testify. So you can pay the homeless man a reasonable fee for a reasonable expenses, and if he has any, not that he's driving there, but if he has parking, if he has any, if he lost any time off of work, generally you can pay a witness. You can't pay a witness for the content of the testimony or that your testimony is contingent upon the outcome, but what you may pay is a witness's reasonable expenses incurred in testifying, which here is probably going to be nominal for the homeless person. Alan then met with Walter, who was living in a homeless shelter, and said to him, look, if you will testify truthfully about what you saw, I will put you up in a hotel until you get back on your feet. Cannot do that. Because what the lawyer is really doing here is buying favorable testimony. So a lawyer may not compensate a witness where payment is contingent upon the content of the witness' testimony or the outcome of the case. By saying, I'm going to put you up in a hotel until you get back on your feet, that's an indefinite period of time. And that goes way beyond paying the reasonable expenses incurred by a witness in having to testify. So essentially, Alan is paying for the homeless man's testimony. And it's improper for a lawyer to pay a witness for even truthful testimony. But to me, it seems like he's actually paying for favorable testimony. No matter how you slice it, there's a violation of the rule, and Alan's paying for testimony. So you could put some of these things in both of them. Paying a witness. Improper. Okay. So, again, let's take a look at the issues that were tested here. The duty of competence, because we have a real estate attorney representing someone in a personal injury matter, which is totally fine. We have a valid contingency agreement, which doesn't need to be discussed. Not telling the client that you're referring the case to another lawyer breaches the duty to communicate. Then we have the fee splitting agreement. We don't know if it's definitely not in proportion to the work performed. And Alan, Tom didn't agree to take joint responsibility, so that's invalid under the ABA. It wasn't even in writing or anything was disclosed to the client, so it's invalid under California. The referral fee, again, is not valid in California because the client was not aware of it. The terms are not fully disclosed, and the agreement between Tom and Alan was not in writing. Looks like Joe might be recommending the lawyer's services, but anyways, you can't pay someone for recommending your services. You can advertise. That's legal as long as it's not false or misleading. But you may pay a witness for reasonable expenses incurred in testifying, but you can't put a witness up in a hotel for an indefinite period of time to obtain favorable testimony. Clearly prohibited by the rules. Anyways, that's a wrap on this essay. This wasn't a very complicated essay, except for that one little mini paragraph with Alan and the $200 gift certificate. That was a little bit confusing, but don't let that little minute detail slow you down on an otherwise great path to being successful. Okay, so that's a wrap for question 1 from 2013 July. Thanks for listening.